good evening, everyone. Thanks for joining us on such a lovely evening and giving up your time. My name's Leslie Taylor. I'm one of the presenters this evening. I'm a dentist, and my colleague Miranda Steeples, a dental therapist, is the other speaker. Just a couple of housekeeping rules and messages for you to start with. If you do have any questions, if you submit them through the Q&A box, and then we'll do our best to answer as many as we can at the end of the webinar. If you have any requirements for technical support, please also use the Q&A box for this, but often refreshing the page will solve any technical issues for you. Just to let you know that you will be sent your certificates, which will contribute 1 hour of verifiable CPD, and you should get that within 5 days of the webinar taking place. It is dependent on your attendance of the webinar through to completion. Okay, so a little bit more about me. I'm a dentist. I qualified a long time ago in Cardiff, and I worked most of my time in general practice, NHS, private as well, but I've also worked in the community dental service, the hospital service. I've worked in special care dentistry and provided care under GA as well. I have been quite heavily involved in education over the years with both undergraduate and postgraduate hygienists and therapists and dentists. And then just before joining the DDU, which was 10 years ago now, I led a dental teaching unit in Talbot in Wales, which looked after a number of foundation dentists at that time. And then for fun, I did a master's in law, which I completed in 2014. And that is my life in a nutshell. Over to you. Miranda's going to tell you a little bit about herself, so you know who's talking about contracts. And then Miranda's going to present the first half of the webinar. I'll take over for the second half. Over to you, Miranda.
Brilliant. Thank you so much, Leslie. So, yep, I'm one of the DCP, the Dental Care Professional Advisors here at the DDU. Work as a dental hygienist and dental therapist, mostly in general practice for about 15-16 years now. Graduated out of the University of Leeds and achieved a master's at the University of Kent as well. As you can see from the slide, I'm quite a busy bee. That's the stuff I do for fun, and for work I split my week between working here for the DDU and also as an educator for TempDent. So you know all about us. We'd really like to know all about you. We'd like to know who we've got registered with us and watching tonight. So we've got a poll that should have come up in front of you now. If you can just hit the box that best describes you. So even if you are duly qualified, if you can please choose the box that you spend most of your time, most of your working time doing. So if you scroll down, there's a few on there, a few different options. Just for our curiosity, really, just so we know who we've got watching and with us tonight. So we're about halfway there. We'll wait for a few more to submit their answers, and then we can see who's here. So typically when we're doing contract reviews, I think most of my day is spent looking at dental associate contracts, but also if you're a dental hygienist or dental therapist member, and you've been offered a self-employed position, we can review that as well for you. So we do quite a bit of that as well. It's a bit of a mix. Okay, so we're about coming up to 3/4. Let's hit 3/4 and then we'll flick on and then we'll see who is here tonight. Okay, let's have a look. We've got 3/4. Okay, so we have got a mixture, mostly dentists. Next biggest group is our dental therapists and dental hygienists, and then a dental nurse, a dental technician. Oh, and one student of dental hygiene. Welcome to you. Fabulous. Okay, so yeah, thank you for joining in with that. It's always good to know who we've got in front of us paying attention to this webinar. So we have got an aim and some learning outcomes for you, because as you know, if you're going to submit this as part of your GDC CPD requirements, you do need to have those, and we're confident that this will cover for you your GDC development outcomes A and D. So for this, it's looking really at the importance of a fair contract for both parties. So whether you're a practice owner who might be giving somebody, a new person, a contract, or if you're someone who's looking for a new job and you've received that new contract, it's about looking at this agreement and seeing, is it fair for both? Is it going to work out well for both of you? And that's what you're hoping for, is to reach some common ground that you're both happy with, that you can both agree with. So we'll be looking some common clauses, the ones that we typically look at when we're doing a review, and then hopefully give you some clarification of those clauses and some of the terms as well that you might come across within a self-employed agreement. So another poll just before you can sit back and relax. So this one is basically about our contract reviewing service. Is this something that you knew about? So before you signed up for this webinar tonight, did you know that we did this? Have you used our contract reviewing service? Have you done it many times, or have you only done it once? Nobody's responding yet. Oh, there we go. We're picking up now. Had you not been aware of it? And had you not had a contract reviewed, but you did know about it? So there's 4 different options there. So again, just for curiosity, just for interest to know who we've got with us this evening. So it is something that's open to you as a member. It's one of your DDU member benefits. So if you haven't done it before, it might be something to think about in the future. And just to keep in mind that typically we aim to do a 10 working day turnaround. So if you have got a new position that you're due to start, please don't send it to us like the night before your first day, because it's very unlikely that it's going to be back with you ready to begin. So as soon as you get that agreement in your hands, as soon as it's sent to you, if you can send it in, if you would like us to review it, then that gives us the time. And it also gives time, if you've got any questions from what we've said, to be able to come back to you if you need any further clarification. So we've got about 2/3 responded. Let's have a look. Okay, and so the vast majority, almost 2/3, were not aware of this service before the webinar. Okay. Well, there we go. So that's one thing that we've learned already this evening. So that's great. Okay, so sit back and relax. Hopefully you've got a cool drink in hand and a pen and paper if you want to make any notes. So why is this important? What is it? Well, it's a comprehensive written agreement, and it's really important because it's needed to make sure that the rights, the obligations, and the financial arrangements are clear for both parties. We can also offer a template. So if you do send in for a review, we can offer you a template within that, which is covered. There's one specifically for dental associates, and then also another one for dental hygienists and dental therapists. And this has been drafted with solicitors who specialise in this area of law. So you can be reassured that the contract template that we send to you is absolutely spot on and will be correct. So when we're looking through the contracts, we check them against what might be considered ideal or what is commonly seen, what we usually tend to see. And if there's areas that members might wish to discuss, so we'll flag them up for you and point them out to you just so you can have that discussion with the practice owner before you sign your agreement. It's also really, really helpful if when you receive your agreement, you can just send it in to us, but if you have a look over it, and if you've got any areas that you're particularly worried about, or you think it's unusual that you'd like us to focus on, then that really does help guide the review that we do. So as you can see from the slide there, basically the bottom line is you need to be understanding what's in front of you. You need to be happy with what that agreement says before you agree to it. We're not going to tell you, oh, this is a good contract, or yes, I think you should sign it. That's not our decision to take. All we will do is help you to understand what's in there, and then you need to decide if it's the right thing for you or not. So how can a review help? Well, in many, many ways, because quite often contracts are quite long. They're quite lengthy documents. There's quite a lot of legal speak in there. They're not always the plain English that we'd like them to be. Sometimes, You know, it started as a standard template and then someone's edited it and moved things around a little bit. You know, they've done things with the formatting, and so there might be a reference in one clause to another clause, and when you look at it, that clause doesn't relate to that first clause, and so on. So we'll help you pull apart those things and pick up any discrepancies or any missing things that should be in there, just to be that sort of critical friend to cast the eye over this agreement. So a lot of them are developed from templates, and they're absolutely fine and they're great. But if a template is fiddled with, if it's, you know, taken away from its original state, it doesn't always make sense. And some of the ones we're seeing, you know, they've been developed by AI programs, and they've got some very odd clauses in there and things that even contradict something else. So again, if you're a practice owner developing a contract to give to somebody, do give it a really, really good read through and make sure that it makes sense before you send it out, because that will speed up that person being able to sign it for you. So it is really, really key. And it's a really helpful way of starting a discussion between you, if you're a clinician waiting to start a job, and a prospective workplace. It's a really good way of sort of feeling out how that relationship's going to be if you need to flag things up, you know, to open up that conversation in the first place. So, yeah, as you can see from the image there, just to reiterate, there's so many different templates out there. And just because it says that it's been produced by a reputable body at the top of it or down in the footnotes, it may have started that way, but it doesn't necessarily mean that it's still going to accurately reflect what was originally produced. Most of them are excellent, and you know, they're kept up to date through editing over the years. But a lot of them are just simply quite complicated. So the plan is, when we do a review for you, that we can help you understand what the intention is. We can help you understand or interpret what the clauses are trying to say, and, you know, make it clear to you before you go ahead and sign it. So a self-employed contract for any clinician, you know, what is it for? Well, it describes the rights, the obligations, and the financial arrangements of both parties. It acts as a record of agreement to help prevent against any future misunderstandings. You know, how many times has something been said, oh, do this, or something happens, and you think, oh, I don't remember signing that. Well, then you can look back at this contract, you can look back at the agreement and check if that clause is in there. It's also really, really important as evidence, if you like, to your self-employed status, because there's usually a statement in there that talks about that you are a self-employed person, you know, that it doesn't mean that you're employed, that you have clinical freedom, and that you have the ability to appoint a locum. Certainly in the dental hygiene and therapy world, I get asked quite frequently, you know, do I have to get a locum? Well, oftentimes, yes, you do. And if your contract says you do, then yes, you do. It's part of the markers. It's one of the markers of being self-employed, is the ability to substitute yourself. And so you can see there's a lot of headings on this slide. These are all things that I typically look at. There's a good sort of checklist for things to look out for. And sometimes when we go through a review, there's nothing really to say, because if what's under, for example, emergency arrangements, if that's fairly standard, then there might not be anything in there. So if we haven't commented on it, chances are it's probably a standard clause. You know, it's common to other agreements that we normally see. So if something is flagged under one of these headings, it's usually in the sense of, you know, check this, have a chat about it. It may even simply be that something's not been filled in correctly. You know, I've seen agreements where it says that premises have been inspected and it's from 2019 and it's been for earlier this year. So it's sometimes things that are just not picked up and that are not accurate. And you really want the agreement to be accurate before you go ahead and sign it. So one of the first things that comes up in agreement is the need for documents to provide. This slide should be fairly familiar to any of you that have started in a new position. These are the standard things that are usually asked for, but that doesn't mean to say that that's all that's going to be on the list. There might be other things that a practice might require you to provide. And this is a really key one right at the start, because it comes up in the termination section. you know, there's quite often a clause in a contract that will say you've got 2 weeks, or it might be some other time limit, that if you haven't produced these documents within that time, that they could terminate the agreement, you know, basically before you've even started. So do double check that. And if you think you're going to struggle with getting something to the practice owner within that time limit, then let them know. Just reach out to them, just explain the situation, and then, you know, come to some sort of compromise. And at the bottom there, we've got read over any policies you may have to comply with. And that's an incredibly broad statement, because there could be a broad reach of policies you may have to comply with. So, for example, something like complaints handling. If something is specified within the agreement and you're being signed to say that you will comply with it, then you need to have sight of it. So I know in places that I've worked in the past, there's been a big ring binder that's full of policies that every member of the team has had to read and sign to say they've read it and understood it. So if you're being asked to sign to say that you're going to comply with different policies, strongly recommend that you would do the same, that you would ask to have a look at them and read them before you go ahead and sign. This is quite a big section, services and facilities. Sometimes it comes under one heading or another. And this is really, really key, because this is going to be your day-to-day. This is going to be typically the room or potentially rooms that you might be working in. And this is all connected with the license agreement, because the license, as it's termed, the license fee, or the license is the permission to use those services and facilities in exchange for a payment. So by looking at these things, by looking at the room, the materials, the equipment, and so on, you're deciding if that's suitable for your needs. Can you work with that? Are you prepared and happy to pay the license fee to the practice owner in order to be able to use these facilities? So that's the key. So oftentimes, again, there will be a clause that says that the facilities have been, you know, shown to the potential clinician. There's usually a date in there as well. So if you've looked, make sure that the date is entered onto there. Sometimes I've seen agreements where the date that the facilities have been viewed is the same as the commencement date or the start date. And that's really not a situation you want to be in. You don't want to be showing up for work on your first day with a diary full of patients potentially, and you've not examined the facilities you're going to be working in. So do make sure to go and have a look around everything before you start. This section is really, really important because it's all to do with the Landlord and Tenant Act of 1954. And it prevents the clinician typically having the right of exclusive use of a surgery or security of tenure. So it's another important part of a self-employed agreement. It basically permits or allows the practice owner to retain control of the facilities and services provided. So hopefully you've had a chance to have a look through the slide there. These are all the different things to think about. But again, this is not an exhaustive list. So if there's anything else that you think of, or any particular piece of kit that you especially like to use, or if there's any, I don't know, particular chair that you prefer, if you've got a back problem or something, then do check that that's going to be available for you. And I will just flag under the meet the staff, you know, as a dental therapist and dental hygienist, there are still contracts out there that don't always make provision for a dental nurse to be working chairside. So if there is something that, you know, that's like a red line for you, or if it's something that you're not clear about, or something you've been told it will happen, but it's not in the contract, then do have a look for that and do have a conversation about that if that is something that is important to you. Thinking about hours, you'd think this is quite straightforward. Usually it is. There's a section for hours. It states the days of the week and the hours that you'll be expected or anticipated to be ready to work and available to see patients. Sometimes this section's not completed. So really quick and easy one for you to have a look at. And if it's not completed, or if it's completed inaccurately, you know, it's not what you're expecting it to say, then that's definitely something to flag up. And there's a term called extra surgery hours as well. So this is not in all agreements, but we do see in some of them. And it's usually a fee for if the premises or facilities are to be used by the clinician outside of those typical surgery hours, which is why it's important that those anticipated surgery hours are defined. Because if this fee is there, then that's how you know if it's going to be extra surgery hours. And one of the key things to look at is this thinking about planned additional time? So say you would normally finish at 12 o'clock on a Friday afternoon, but you want to work an extra couple of hours till 4 o'clock, or you want to open up on a Saturday morning. Is this extra surgery hours for planned additional time? Or is it something you're going to be charged for if, say, you run late by 15 minutes? So it sounds quite pedantic, but with this sort of thing, you really do want to nail down the details. So do look out for that one as well. And emergency arrangements. Again, this doesn't appear in all contracts. And so if you don't see it, don't assume that there's no obligation for you to do it, because we have an ethical obligation to be able to provide care for patients, and patients need to know what's happening if they do need care in an emergency situation. So it's a really good idea to find out, what are your obligations? Is it some sort of rota? Is it done on a friendly basis within the team? And particularly if you are a dental hygienist or dental therapist, is this appropriate for you? How would this work for you? Is it a sensible thing for you to be put onto an emergency rota when patients might come in with a problem that might be outside of your scope and you're not able to help them? So do check that. Time in practice and time away. This one can sometimes, take a little bit of checking. It can be a bit contentious at times. And ultimately, this is just simply for you and the practice owner to make a decision, come to a compromise that you're happy with. Obviously, the practice owner, they're running a business. They'll be working to strict budgets that they've made. Patients, will have an expectation to be able to be seen. So it is very, very important to come to a mutual understanding, something that works for the both of you, that is fair for both sides and also fair for patients. So there's always a degree of freedom. Usually it can be done by a conversation between the two parties. But sometimes the use of practice facilities can be quite clearly defined as well. And do be careful with different terminology. We don't really want to be seeing things like holiday or annual leave, because that's not really appropriate language for a self-employed agreement. Typically, we'd be looking at things like time away from the practice, or the opposite of that, of phrases like the surgery will be made available for use. Surgery must be used between these hours, something like that. Just really to keep it very within the boundaries of a self-employed agreement. Usually we'd see a clause in there about public holidays. Are they going to be open, closed? What's the obligations for emergency cover? Are you going to be given time for study leave? And how much notice do you need to give? That's very, very variable. So do make sure before you sign that you're very clear on what notice you might be expected to give. And locums, as I said right at the start, it is a fundamental right of being self-employed to be able to substitute a locum to fulfill the obligations that you have under the contract. And again, the defined number of days after which a locum would be engaged is quite variable. There's some agreements that it will be for any time that you want to take away from the practice. You would need to engage a locum. Others, it could be a few days or a couple of weeks. That's something to double check, make sure that you're happy with, speak to the practice owner about, and also to look at, how they want you to do this, because oftentimes there'll be a clause in there as well that if a locum is needed, and if you haven't done it, then the practice can do it on your behalf and they might charge you for it. So it's always wise to see, if that was the case, what is this fee likely to be? And also, how is that locum going to be paid? Who's responsible for sorting out their remuneration? Payment schedules, targets. These are ones normally right at the bottom, the schedules. So you'll read through your agreement. You'll get to a page where the practice owner or the principal has signed, and there'll be a space for you to sign as well. And commonly the schedules come after that. So don't just get to the signing page and think, oh, that's okay, that's it, because it's not. There's often a number of schedules at the end. And this is where you'll have information about how you're going to be paid, if you're working under the NHS system or the private system. Are there going to be any deductions? If there are, what are they? Have they been stipulated? Have you got any targets? Are these targets accurate to what you've agreed, to what you've discussed? these are all going to be within this sort of back end of the contract. So do have a really good look through and be sure that it's what you're expecting it to be. And if anything's not quite what you're expecting it to be, then certainly have a conversation with the practice owner about that. And termination, it does seem a little bit, negative to be thinking about termination before you've even started the job, but really, really important to check those clauses. What is the notice period? Typically, we would expect to see 3 months for both parties. I know myself, I've had agreements in the past where it was I had to give 3 months and the practice only needed to give me 1 month. Whatever the agreement is, you need to be sure that you are happy with it. Sometimes there'll be an earliest termination date stated, and the minimum term is usually quite clear, or at least it should be. If there's one that's going to be used, it's usually set out quite clearly. So if it's not clear and you are expecting, perhaps it's a fixed term agreement or like a maternity cover or something like that, or if for any other reason there's an earliest termination date, do make sure that you're aware of that. And also do check, because sometimes if you do want to exit an agreement before an earliest termination date, sometimes that comes with a fee. So do double check that, make sure that you fully understand what you're signing with regards to any sort of termination clauses, because once it's signed, you really should expect to be bound by that. And there's usually something in there as well about continuing care arrangements for patients. Sometimes the practice will take on all of the care. Sometimes there might be some exemptions to that. And those exemptions are typically down in a schedule at the end. And it's usually pretty clear. It's going to be things like if you're doing orthodontic treatment, for example, it might be that there's the expectation that you will return and take care of those patients until their treatment's completed. So again, if you're thinking of finishing a job and emigrating to the other side of the world, you will need to have a conversation with the practice owner about that continuing care for patients. So that's the end of my little section. Leslie is there ready to come in with the next section. So yeah, I will hand you over now to Leslie. Thank you.
Thank you, Miranda. Okay, there's one part of termination that often clinicians, dentists, therapists, hygienists do get upset about, and that's the retention fee. So retention, what we mean is an amount of monies that is held back by the practice on termination of the agreement. The reason for holding it back is so that if there was any remedial care that one of the patients may require, then that can be used to fund that care. Which, although this may seem a little counterintuitive me saying this, but that's actually quite a good thing that there's a retention fee, because it can, if it's used appropriately, it can help to reduce the chance of having patient complaints. But as this slide says, it does need to be, that retention amount needs to be properly managed. There's various ways of calculating the retention fee. There isn't a right or a wrong, and this is why it's important that you understand the contract and how it's calculated, and that you agree to it before you start, before you sign the contract and then you begin work at the practice. But the two favourite ways would be that the practice owner would take a percentage of the final 6 months of your average income, or they might just take the entirety of the final month's income, and that would be the retention amount that you leave behind on termination of the contract to be used, as I said, to fund for remedial care. If that is used properly, and if it's not used at all, actually, it doesn't matter how much it is, because you should get it back at the end. There'll be a defined period after which that retention amount will be returned to you. It may well be returned in portions at specific intervals, but whatever's left should be return to you. You will see, well, not in all contracts actually, but you will see in many a maximum permitted spend. Now, what that is, it's an amount beyond which the practice would seek your input before spending above. Yeah, so for example, if you worked in an NHS, a practice that was delivering only NHS care, and the maximum permitted spend was £500, then well, you can see that, you know, that would probably eat into your retention fee quite easily if you weren't involved in the decisions around what it's spent on. Hence me emphasising the importance of it being managed appropriately. It's a good thing when it's managed appropriately, but things like maximum permitted spend and the retention amount, they're not set in stone. It depends on the practice, it depends on the fee scale, and if there's something you don't understand about it or you don't like about it, then these are concerns that you should raise with the practice owner and seek to maybe as a negotiator some mutually agreeable amendment to that part of the contract. So yeah, whoops, it's retained fees for remedial treatment. That's essentially what it is. Now, another thing, protection of goodwill and restrictive covenants. Right, goodwill, what is goodwill? It's the value of the business. So when you leave a practice, the practice owner wants to protect the value of their business. In other words, they would rather their departing associate therapist, hygienist, not take all the patients with them and neither take all their good staff. So the practice owner will seek to protect the goodwill, the value of the business. And to do that, they will insert what we call restrictive covenants into the agreement. So restrictions in terms of the area and the time period where and when you are use allowed loosely, allowed to work once you've left that practice. So as an extreme example, say you may have a restricted area of say 5 miles, and you don't want you to work and see patients from this practice within 5 miles and within 2 years of leaving the practice. Right, that's fine if you're living in Powys in mid Wales, massive area. You probably wouldn't find two practices very close together at all. But of course, if you're in central London, that might be problematic. So if you saw that in your associate agreement, then that's probably something you might like to bring up and discuss with the practice owner. So it makes sense. The practice principle, they're trying to protect the value of the business. So they're going to place restrictions on you by virtue of the contract, so that you're not taking business away when you leave. So you do need to think about that, although you haven't even started the practice and you're thinking about leaving, but you do need to think about, well, what do I want for my future career? Might I want to work locally? Might I not? All these things need to be taken into consideration when you're thinking about restrictive covenants and where you might like to work in the future. Now, what will happen to your patients when you leave? Well, we've already said that the goodwill belongs to the practice and the practice owner wants to protect that. So your patients should essentially return to the practice. So it's very, very common, and ongoing care will return to the practice owner, either for them to treat the patients themselves or allocate to another clinician at the practice. but this is something that it should be written in the contract. It may be listed in the one of the schedules at the end, but you want to be sure that you're able to comply with it. Remembering what Miranda said a moment ago, things like, in my experience, it's been short-term orthodontic care. Invisalign, for example, the practice owner may expect you to return to complete it. Care with implants, they may expect you to return to complete it, or at least make provisions for onward referral. So that is about continuing care for patients once you leave. You should check through your agreement to make sure that it is complete. Now, this seems really obvious, but the amount of agreements we do see that they are incomplete, inaccurate, is quite a number. So be clear about agreement date. Agreement date is the date you would sign and that you agree with your contract. The commencement date, that's a different date, so that's when you're going to start at the practice. Ideally, you would expect those. It would usually be different because you'd have signed it, you'd have agreed it, you'd have negotiated it, you would have taken advice on it, you'd have discussed it, etc., at a date far in advance of then agreeing and then commencing. Make sure your name's on there and it's correct. Make sure the practice address is on there, the principal name is on there. Make sure that hourly rates are clear, that your UDA rate is clear, your target rate is clear. There shouldn't be, if it's a template, and they often are templated contracts that practice owners use, that nothing should be left blank. It should either be completed, or if it's not going to be used, delete it. Make sure that the days you're going to work there are in there and the times that the surgery is available to you. So they are just a few examples, but they're often the things that they're in boxes on a template and they haven't been completed. You don't really want to be signing an agreement with empty spaces. Either get it completed, if it's not relevant, delete it. This is talking about incorrect areas of an agreement. Check, get your red pen out, check spellings, check your contact details are right, check all the practice and principal details are right. I've often seen, say if it's an agreement so you're just solely providing private care, you certainly don't need references to the NHS in there, so that can be deleted. You want to be going through the agreement with a fine-tooth comb. You're looking for inaccuracy and things you're not sure that you've agreed to. Make sure that well, this is for the practice owners probably mostly, but that the document dates is correct, such as GDSO's scope of practice. If that's referred to, it should be the up-to-date scope of practice. If GDPR, data protection regulations, is referred to, that should be the up-to-date version. For example, I have seen contracts that say the practice charges the patient a fee to have a copy of their records. Well, that was correct a few years ago, but on the current regulations, that's incorrect. You cannot charge patients, or should not charge patients just for a simple copy of their records. So be aware of things like that. So when the practice is referring to certain documents, policies, make sure they're correct, make sure they're up to date. Miranda's already touched on about formatting errors. We do see contracts that clause 1 references schedule 6, and you go to schedule 6, it's either not there or it's something a completely different topic. So make sure it's formatted correctly, and then each person looking at the contract, it's clear to them, everyone has a common understanding. Now, vicarious liability, this can cause a little bit of stress for clinicians and practice owners in particular. Vicarious liability, all it means is that it's a legal action that maybe is a solicitor or a patient, usually a solicitor, would bring against a practice owner for treatment that hasn't been provided by the practice owner, but it was provided by one of the practice owner's self-employed staff, such as the self-employed associate, the self-employed therapist or hygienist. There's various reasons why solicitors firms do that, and often it could be something as simple as, well, there's a lot of clinicians involved and this is the easiest approach for them to take. But vicarious liability is something that our practice owner members of the DDU, they are, that is included in the membership of the DDU. So they are, practice owners are indemnified for vicarious liability if there was any clinical negligence claims attempted through that route. But it's a reason for practice owners wanting to keep in contact with the departed clinician. You may think as a departing clinician that, well, it's a good reason for me not to keep in contact, but actually you'll probably be sought out and it's important that you do keep in contact with the practice, because you may have opportunity to dampen down the potential for any patient complaint. So there are good reasons for both parties keeping in contact with each other once the contract has been terminated. The GDC does require, if we're seeing patients, that we are adequately indemnified. And the practice will, as one of their initial checks, will no doubt want to see that you are indemnified and GDC registered. So you can't work without those two things. So that's evidence that they will seek. And if I was a practice owner, it's something I'd want to seek each year, just to make sure that my my associates, therapists and hygienists were indeed registered and indemnified. So record of that. Yes, and of course, GDC requirement to state, yeah, you're adequately indemnified when renewing your registration alongside paying your annual retention fee. That's what ARF is, and then submitting sufficient CPD hours for your role. Okay. Now, self-employed status. A lot of practitioners are quite protective of the self-employed status. It does bring with it certain advantages. Of course, arguably it could bring disadvantages as well, but that's very personal to you, what kind of employment you want, whether you want to be self-employed or employed. But given that a lot of practitioners in practice are quite protective of it, then we'll talk a little bit about how you would protect that and be able to demonstrate it. HMRC, the tax man, has increased the scrutiny of dental practices, because of course they're seeking, you know, how they want as much tax off us as possible, don't they? I'll try not to get political, but they do like to take our tax, and if there's an opportunity to extract more tax, they will do that. So And it's generally thought that with self-employed status, particularly because you can offset certain expenses against your business, that you may be better off to a degree. So there is increased scrutiny by HMRC. I'm no accountant, so when you want to know about things like there's a regulation IR35 changes which were introduced back in 2021 about tax. They are topics that your accountant, and you should have an accountant who can discuss and deal with for you and with you. Essentially, if you're going to be able to demonstrate your self-employment status, self-employment should come with a degree of freedom for the clinician, limited control by the practice owner. If you were employed, the practice owner would take more control, maybe restrict your freedom. They would talk about you can only have this many holidays, for example, as opposed to the self-employed clinician who you're expected to use the facilities for a certain amount of time. We try not to refer to holidays. It's a little bit subtle and a little bit nuanced, but it seems to work at the moment. There's got to be financial risk for the clinician as well if you're going to be self-employed. Not a nice thing, and that arguably is a disadvantage, and why some may prefer to be employed. But if you're going to be self-employed, there is a degree of financial risk, and the ability to arrange a locum, substitute yourself with someone who can do that job for you if you're away from the practice beyond a certain amount of time. There is a tool on the HMR website, check employment status for tax tool you could look at. But yes, there are advantages, disadvantages to self-employment status. At the moment, certainly it seems to be favoured by practice owners and associates, and something that people are eager to protect. So your tax wouldn't be deducted at source as it is for employees. That's not going to happen. You pay it yourself after deduction of expenses. And practices are not liable for employers' national insurance contributions. Another reason why the practice owner might want you to be self-employed. No holiday pay, no sick pay, no maternity pay, no pension. All disadvantages, but there are other ways of getting around that for things you would speak with your accountant or an experienced financial advisor. There should be a clear statement of your self-employment on the contract. They'll describe the license. They'll talk about your freedom, your clinical freedom, the ability to appoint a locum. And you've got to be absolutely clear what you are signing and that you are happy with the agreement, because once you've signed, you should expect you're bound by it. You should assume it's legally binding, okay? So just to get the negotiation off on the right foot, I don't intend to concede on anything. Probably not a good starting point. When all said and done, it's an agreement between two individuals. You both need to understand it, but you also need a mutual understanding. It's no good, I understand it, you understand it, but our understandings are different. You need a mutual understanding. Anything not clear, you need to raise it and gain clarity, negotiate anything that doesn't make you happy. I think that is I'm very alert to the time. It's 10 to 7. This is information about our advice line, which is available. and our membership team. This is how you can contact us, of course. And just a reminder that you will be emailed a certificate. It's 1 hour of verifiable CPDs. That should come within 5 days of the webinar. This webinar is available on Watch on Demand, but wait a couple of days and it will be on the website. There will be, we have got time for some questions. Any questions that we don't get to, we'll publish on the website, just to let you know. And then at the end of the webinar, there will be a short survey which will pop up, and we'd really appreciate any feedback you provide. So let's try, and we've got 9 minutes. We'll take some questions. So let's have a little look at some questions. Okay, right, number 1 question. Now, this is the first time me seeing this question, and probably the first time Miranda reading it too. So if you change your working days, e.g. opt for more or less days, do you need to amend your contract once you have already started the job? Second part of the question then. And also, do you pay and UDA targets change? Right. Miranda, would you like to have a shot?
So I would say, yes, there needs to be some sort of amendment there.
Absolutely.
If you're changing your terms, then the agreement does need to reflect what you're doing, doesn't it, Leslie?
Yeah. If you're going to change it, agree it, write it down, both parties sign it, and then what you're doing is you're making it really clear between the 2 parties, and you're avoiding misunderstandings, because if you can do that, you'll mitigate your chances of, well, basically having a row in the future. Yeah.
And so even if it's
you pay UDA, your targets may well change. Yeah, probably, more than likely.
Yeah, what you don't want is a conversation in the staff room at lunchtime. You can have that, but then I would follow up with an email just sort of saying, just to clarify the conversation we had earlier, can I confirm that we have agreed, and then get them to email back to say, and ideally with the contract amended. Yeah, for sure.
It's a little bit like saying when people talk about an audit trail, which is all you're doing is you're creating a document which acts as the evidence to demonstrate that this is what you agreed. Yeah. You don't want that scenario. I know I didn't.
You don't want the he said, she said. Keep it clear. Absolutely. So alongside that, the next one, how do you deal with a practice owner that hasn't given any hygienist a contract, agreed for one to be made in the meeting, but never follows on from there? Well, I would say both parties are quite vulnerable without having a contract in place, both the practice owner and the dental hygienist. In fact, any clinician really would be vulnerable, because you need those parameters. You need that notice period. You need the pay agreements, leave, taking time away from practice, things like that. So I would just keep asking. And as Leslie said, make that audit trail, send an email, so you've got it in writing that you have requested a contract. Is there anything you'd add to that, Leslie?
Well, I'd say I realise that, you're already working at the practice at this point, but if you step back, we go back from that. Don't start without, I realise I've already done that, but try and in going forward for the future or for anyone else, don't start without a written agreement. Otherwise you don't know, how are we, practice owner and me, how are we going to work together as a business? How am I going to get paid? When am I going to get paid? You want to know this. I'd sell it to the practice owner this really is in your interest. Could you write it down for me how you intend, so that it's clear to you and it's clear to me? I think that maybe asking, yes, but maybe trying a different tact. This is a really good thing for both of us. We should really have it written down. Otherwise, you are in a he said, she said, I thought you were going to pay me yesterday, you still haven't paid me, and now it's next week, and I never said that, and you're in difficulties. So get the basics written down, agreed, signed. Yeah.
Yeah. And I think that I've just had a thought then, Leslie. So we're talking about people who want a contract who haven't got one, and most of our presentation has been around, you've got a contract, look at it before you sign it. But there's also going to be people out there who have been given a contract, but who have not signed it, but they've started.
Yeah,
and I've certainly seen some clauses, and it will say that along the lines of that, even if you haven't signed the agreement, the fact that you've started work, and especially once you've accepted that first remuneration for services, that you will be deemed to have accepted the clauses in the agreement, even if you haven't signed it. I have seen that a couple of times.
Yes, me too. Yeah, quite right. Yeah. Also, just thinking about that question, we've got templates. So say it's a hygienist. If you wanted a hygienist template, if you as a DDU member, you wanted a hygienist template to present to the practice owner, make it simple for them, you could show them that, for example. Yeah.
Oh, absolutely. Yeah, that's a great idea. Yeah. And if it's some of the professional organisations as well for dental hygienists and therapists, they've also got their own contract template as well that could be useful. So yeah, we've had another question. It says, in cases where some of the premises are somewhat dubious, can contracts be reviewed and altered retroactively?
I almost read that as two. I might be misunderstanding, but it's almost two questions to me. Premises dubious. I don't think you mean the building and the surgery. I'm not sure you mean that, because you wouldn't have started work if you thought it was dubious.
I hope not.
If contracts are reviewed and altered retroactively, you mean like surreptitiously, something like that? I suppose somebody could, but that makes them vulnerable, doesn't it, to some sort of criticism for dishonesty and misleading, etc. And you're doing it if it's going to be if you're going to amend, we don't say alter, say you're going to amend the contract between two people, you would both do that together, and you would both sign it. So yes, so that shouldn't happen. That shouldn't happen, and it wouldn't be good for the person who was altering it.
Yeah, absolutely.
Yes. Okay, there's another question. Can we ask for sick pay on agreement as a UDA-based dentist? On self-employment, I'd say probably nah. Because it's forget the UDA bit. If you're self-employed, you wouldn't get sick pay. So if you're employed, I've worked in a community dental service. If I were sick, I'd get sick pay. I've worked as an associate in practice. I'm self-employed. I don't get sick pay. But what I did do is I did take out some insurance in case I broke my leg for 2 months, something like that. So that's the way you get around it. But you can ask for whatever you like, but the chances of you getting it are nil. I think that also infers that the UDA is almost, and I think that's the problem that HMRC and the taxman have with UDAs. It's almost starting to fall into the category of being salaried as opposed to a fee per item, where there is more financial risk to the clinician. That's probably a more complicated, complex answer is deserved than the tiny question allows. But if I was to give one word to answer to that, it would be no.
No. No, you're yeah, I would agree with you, Liz. It's very, very unlikely. So yeah,
right.
with about 10 seconds
Miranda.
left. Yeah, so just we've had lots and lots of questions. So thank you so much for engaging with us. Thank you for doing our polls. Thank you for answering the questions. That's all we have got time for now. We will be providing written answers to questions that we didn't have time to answer, and they'll be published within the on-demand webinar area of the website. So at the end of this, when we say goodbye, a very short survey will pop up, and we would appreciate any feedback you can provide. Thanks very much for listening.
Thank you, and thank you for staying with us. Have a good evening. Bye-bye.
Bye. Bye.